Hearing in the appeal of arms against Nottinghamshire County Council.
Is this not?
May it please your ladyship in the court. In this case, I appear with my learned friend Mr. Davey for the appellant, Natasha Arms, who was the claimant at first instance and the appellant in the Court of Appeal. My learned friends Mr. Ford, Queen's Counsel, and Mr. Weitzman, Queen's Counsel, appear for the respondent. We all also appeared in the Court of Appeal. I did not appear at first instance, but the others did. Ms. Arms is here in court, on the row behind me. We intend that our submissions today, including introductory remarks, will last no more than 4 hours. This morning I intend to deal with the question of vicarious liability and something dealing to an extent with the facts. The question for the court is whether a local authority, not personally at fault, may be held liable to compensate a foster child deliberately abused in the foster home by one or more of the foster parents. Seeking to answer the question, it's necessary to consider the doctrines of vicarious liability and non-delegable duties, and it's necessary to consider whether it may be fair, just and reasonable to impose liability in either instance. Our submissions will address those 3 headings in that sequence, and I intend to break each heading down into separate topics. Vicarious liability, the introduction. The County Council accepts that if the relationship between the foster parents and the council was of a sort such as to render it potentially liable for the abuse in question, the necessary connection exists between the abuse and that relationship. Hence, this court is concerned with the primary question: was the relationship between the foster parents and the county council indeed of the sort as to render them potentially liable for that abuse?
Well, you have, of course, filed with the court an extremely clear and comprehensive written argument. So there's no need for you to repeat what you say in that, and I'm saying that to both counsel.
Look, my lady, that's it so far as I'm concerned. But I'm conscious that not everyone in the court seated behind me has the benefit of our submission. So
That's very considerate of you, Mr. Melton. Thank you.
And I know, my lady, of course, that they have the crib that's handed out at reception, so perhaps it was not necessary for me to give that outline. We'll deal first with the legal requirements that need to be satisfied before such a relationship can be said to exist. We will then look at the legal and factual context in which Natasha Arms came to be fostered. Next topic, Cox and the Ministry of Justice. The starting point for consideration of this primary question is obviously the case of Cox, in which judgment was given last March. It had previously been said that vicarious liability was on the move. The decision in Cox clarifies the distance travelled. Cox makes plain that whereas the employment relationship is, to adapt slightly Lord Reed's words, a classic example of the sort of relationship that gives rise to vicarious liability, it is now far from being the touchstone that determines its presence in a given case. Since judgment in Cox was only given in March last year, neither the lower courts in this case nor the higher courts in other jurisdictions had the benefit of its reasoning. In our written case for this court, and I won't go to it, but it's at paragraphs 7 to 9, we have attempted, presumed accurately, to summarise the reasoning. But already now, in summary, we say that Cox decides that the 5 factors, policy reasons, or incidents that Lord Phillips, in the Christian Brothers case, identified as making it fair, just and reasonable to impose vicarious liability still stand, but importantly emphasises that they have unequal weight, which is perhaps not surprising. It decides that depth of pockets alone will carry little weight. And it decides that whereas some vestigial control is essential, what really matters about control is that the defendant can direct what the tortfeasor does, not how he does it. And I know, of course, that the court will be extremely familiar with the case of Cox, but I'll be forgiven, I hope, if I invite the court to look at the court's treatment, and in particular Lord Reid's treatment of the Christian Brothers case.
Well, Lord Reid and I are familiar with the case.
Yes, well, I don't...
It's entirely possible that Lords Kerr, Clark and Hughes are familiar with the case, but it's also possible that they're not.
In that case, I'm sure I will be forgiven for doing what I intended to do.
That's what I'm saying, you will be forgiven. Yes.
Well, we have become familiar with it because of its centrality to the issues in this case.
It is absolutely central, my lord. So, authorities bundle, divider 5. Page 705 on the memory stick. This is, as I repeat, this is the court's treatment of consideration of Lord Phillips. And I would invite the court to read, rather than my reading out, paragraphs 18 and 19 on page 705. Or perhaps in the circumstances, I'll read out the important paragraph 19, because these 5 factors are so important.
You might read out the 5 factors.
That's what. There is no difficulty, just beneath letter F, in identifying a number of policy reasons that usually make it fair, just and reasonable to impose vicarious liability on the employer when these criteria are satisfied. 1, the employer is more likely to have the means to compensate the victim than the employee and can be expected to be insured against that liability. The relatively unimportant deep pockets point. 2, the employer is more likely to have, the tort will have been committed as a result of activity being taken by the employee on behalf of the employer. 3, the employee's activity is likely to be part of the business activity of the employer. 4, the employer, by employing the employee to carry out the activity, sometimes we use the word function, sometimes we use the word activity, and I might end up using them interchangeably, will have created the risk of the tort committed by the employee. 5, the employee will, to a greater or lesser degree, have been under the control of the employer. And I'll just flag up that the distinction in relation to control, which is now diminished in importance as the result of recent developments, in the case of when we're dealing with vicarious liability, it's control over the employee that's important. Whereas when we come to consider non-delegable duties, it's the assumption of some control over the injured person that is relevant. And then, carrying on, at paragraph 47, Lord Phillips added, I have identified those incidents of the relationship between employer and employee that make it fair, just and reasonable to impose vicarious liability on a defendant, where the defendant and the tortfeasor are not bound by a contract of employment, but their relationship has the same incidents. That relationship can properly give rise to vicarious liability on the ground that it is akin to that between an employer and an employee. So whilst historically it may have been said that the relationship was necessary to found vicarious liability, the more modern way of thinking is that it is sufficient, but by no means necessary, for the reasons we'll learn when we come to deal in more detail with the case of Cox. And the focus of the judgment of my Lord, Lord Reed, in Cox was on the important and, as is emphasised, interrelated second, third and fourth factors adumbrated by Lord Phillips. And that interrelationship and their importance is crucial, we say, to Lord Phillips' sophisticated approach to the question of vicarious liability. And it will be on those three factors that we will direct our focus today. I'll invite the court to turn to consider paragraphs 22, 23 and 24, which are at page 7 and 6. And because of their importance, my intention is to read them out, but if it's found to be more helpful than to be read in quietly, then of course I'll be told.
See how you go.
Yes, see how I go. Thank you.
You needn't read them very slowly.
I need not, no. The remaining factors listed by Lord Phillips were that, 1, the tort will have been committed as a result of activity being undertaken by the tortfeasor on behalf of the defendant. 2, the tortfeasor's activity is likely to be part of the business activity of the defendant. We'll come to deal with what business means shortly. And 3, the defendant, by employing the tortfeasor to carry on the activity, would have created the risk of the tort committed by the tortfeasor. These 3 factors are interrelated. The first has been reflected historically in explanations of the vicarious liability of employers based on deemed authorization or delegation, and cases are quoted and cited in support. The second, that the tortfeasor's activity is likely to be an integral part of the business activity of the defendant, has long been regarded as a justification for the imposition of vicarious liability on employers, on the basis that since the employee's activities are undertaken as part of the activities of the employer and for its benefit, the employer's benefit, it's appropriate that the employer should bear the cost of harm wrongfully done by the employee within the field of activities assigned to him, and cases are cited. The third factor, that the defendant, by employing the tortfeasor to carry on the activities, will have created the risk of the tort committed by the tortfeasor, is very closely related to the second. Since the risk of an individual behaving negligently, or indeed committing an intentional wrong, is a fact of life, anyone who employs others to carry out activities is likely to create the risk of their behaving tortiously within the field of activities assigned to them. The essential idea is that the defendant should be liable for torts that may fairly be regarded as risks of his business activities, whether they are committed for the purpose of furthering those activities or not. And then, again, authorities are mentioned and the basis for that assertion. And Lord Nichols, the citation from Lord Nichols is worth reading. The underlying legal policy is based on the recognition that carrying on a business enterprise necessarily involves risks to others. It involves the risk that others will be harmed by wrongful acts committed by the agents through whom the business is carried on. When those risks ripen into loss, it's just that the business should be responsible for compensating the person who has been wronged. Lord Phillips' analysis in the Christian Brothers case wove together those related ideas so as to develop a modern theory of vicarious liability. The result of this approach is that a relationship other than one of employment is in principle capable of giving rise to vicarious liability where, first, harm is wrongfully done by an individual who carries on activities as integral. This idea of integration is an important one, I repeat. Integral part of the business activities carried on by a defendant, and for its benefit, rather than the juxtaposition, rather than his activities being entirely attributable to the conduct of a recognisably independent business of his own or of a third party. So was the foster parents' business entirely their own? And two, where the commission of the wrongful act is a risk created by the defendant by assigning those activities to the individual in question. I will read also the next paragraphs 25 and 26, but will allow the court to read paragraph 27. So, Lord Phillips illustrated the approach which I have described, Lord Reid described, by considering two earlier cases in the Court of Appeal. He discussed first its decision in Via Systems, which concerned a situation of a kind which commonly arises in modern workplaces. Employees of the third defendants were supplied to the second defendants on a labour-only basis under a contract between the two companies and worked under the supervision of a self-employed person also working under a separate contract with the second defendant. The question was whether the second defendant, as well as the third, was vicariously liable for the negligence of the employees in the course of their employment. The Court of Appeal agreed that it was, but for different reasons. Now, Lord Justice May considered that the imposition of vicarious liability depended on who had the right to control the employer's activities, whereas Lord Justice Ricks, whose reasoning was adopted, formulated a test which was based not on control of the employer, but on the integration of the employees into the employer's business enterprise. Lord Justice Ricks stated that vicarious liability was imposed because the employer was treated as picking up the burden of an organisational or business relationship which he had undertaken for his own benefit. Accordingly, what one was looking for was a situation where the employee in question, at any rate for relevant purposes, and that may be an important rider, is so much a part of the work, business or organisation of both employers that it is just to make both employers answer for his negligence. And here, the work, business or organisation of the foster of the local authority was multifold, but included in particular the promotion of the welfare of the child, the maintenance of the child, and the accommodation of the child, all of which are subsumed within the role of the local authority to act in a position of parental responsibility. And importantly, Lord Phillips, as Lord Reid said, endorsed the approach of Lord Justice Hicks, apparently favouring it over the control approach preferred by Lord Justice May. Lord Phillips next considered the decision of the Court of Appeal in the Our Lady of Charity case. There, a diocesan trust, treated as being equivalent to the diocesan bishop, was held to be vicariously liable for sexual abuse committed by a Roman Catholic priest when visiting a children's home in the diocese, on the basis that the relationship between the priest and the Roman Catholic Church was akin to employment. Lord Phillips summarised Lord Justice Ward's approach as asking whether the workman was working on behalf, foster parent here, whether the workman was working on behalf of an enterprise or on his own behalf, and, if working on behalf of an enterprise, how central the workman's activities were to the enterprise, and whether these activities were integrated into the organisational structure of the enterprise. And anticipating a point that I may try to develop in argument, it will be our submission that the activities of the foster parents were central and were integrated into the structure because they were the people who were, after all, accommodating, feeding, clothing, bathing, taking to school, doing all the necessary parts of bringing up a child. Lord Justice Ward had found it possible to describe the relationship between the bishop and the priest as being akin to employment, as Lord Phillips put it, by treating the ministry of the Roman Catholic Church as a business carried on by the bishop, by finding that the priest carried on that business under a degree of control by the bishop, and by finding that the priest was part and parcel of the organisation of the business and integrated into it. And because I don't want to read too much out, but I think it is important that it is read, could I invite the court to read paragraph 27?
We're there.
Thank you. Before going to paragraph 28, what I'm going to say is what I think it says. In borderline cases where the criteria may be insufficiently precise, the court has to make a judgment based at least in part on previous decisions. So, rather than read it out, I'm going to ask the court to read that paragraph 2. But more than that, the court has to take into account the need to extend protection for the victims of torts in order to deal with modern workplace relationship changes. The focus has to be on the defendant's activities and the risks that attend those activities, because prevailing thinking is that organisations should be responsible for the risks created by those activities. It is necessary to read paragraph 29 with the greatest, if I may respectfully say so. This is so succinctly put that
We understand the problem that you have, Mr. Milton, basically.
Thank you. Can I just, though, before, or as you're in the course of reading it, just emphasise that which you said at letter D, which is the prevailing ideas point, and crucially, really, it's the dichotomy between running one's own business and doing somebody else's business for them. And the reason why this court, the Supreme Court, needs to deal with cases as a matter of principle is, if I may respectfully say so, because times do change. We encounter, we're told, times of austerity, forms of delivery change, things get outsourced, as we saw in Woodland. But what this court may think has to be done is to establish enduring principles that can apply and survive sensibly, even in times of change of forms of delivery or organisation. What weighed, the point in paragraph 30 is, it doesn't need to be a business in the sense of a commercial enterprise. And then Lord Reid quoted with approval, paragraph 31, this is on page 710 at the top, the analysis of Professor Bell in his article. And I can summarise it by saying that what weighed in E and in the Christian Brothers case was that the abusers were placed by the defendants in a position in which they committed a tort, the risk of which was inherent in the activities assigned to them. It doesn't matter that the object of the organisation is the service of the public good rather than a commercial objective. And having thus enunciated the principles, Lord Reid considered their application to the case of the prisoner working in the prison kitchen, which is the case in Cox, obviously, and decided that such work was integral to the activities carried on in furtherance of its aims, which included not only the incarceration, but also the rehabilitation of prisoners. And their performance, and I should say, Lord Reid decided that the prisoner's performance of that work created the risk of injury that eventuated. Their activities form part of the operation of the prison. What I say is, lest it be thought that the physical structure of a prison was material in a way that might make a foster parent's private home in some way materially distinguishable, Lord Reid pointed out later in paragraph 38, you don't need to do it straight away, I don't think, that prisoners could be allocated to work in a variety of places, not all of them within the 4 or more walls of a prison. Finally, for now, we need not always ask, according to Lord Reid and the Supreme Court in Cox, the broader question as to what is fair, just and reasonable. But conversely, nor should we slavishly follow the words of a judgment as if they were the words of an Act of Parliament. And the reason why we say that emphasis needs to be given to the point that we don't need always to ask the broader question is this, that if we have carefully crafted principles that have a degree of permanence or semi-permanence about them, then the danger is that if we allow nebulous concepts such as what is fair, just, and reasonable to have too great an influence over the advice that we give and the decisions that judges hand down, then the law becomes less predictable and more subject to the vagaries that arise as times change. I'm not suggesting for one moment that one doesn't take account of the heed of modern ways of delivery, but indeed one does take it into account, but one should not, we say, always have to ask that question. So, next topic. Vicarious liability, the second, third, and fourth factors. The second, third, and fourth factors are, as we've seen, closely interrelated. What we say is that so far as the second factor is concerned, there can be no doubt, and I don't think this is being said, the opposite is being said, that the tort was committed as the result of an activity being undertaken by the foster parents on behalf of the authority. We'll look shortly at the statutory background and at what happened on the ground in this case, in Natasha Arm's case, because both the statutory background and what actually happened in her case both shed light on the application of these various criteria to this case. But for the time being, and by way of flag, we note that the foster parents who performed the important function or job assigned to them on behalf of the authority of accommodating and maintaining Ms. Arms were selected, approved, trained, guided, appraised, and monitored by the local authority, and themselves fed back information to the authority for the purpose of fulfilling the authority's child protection business, to transpose that word. Evidence of integration and evidence also of control came in the form of oversight of holidays, oversight of childcare by third parties, control over numbers, so that in one case they weren't allowed to foster more than 9 children in addition to their own at one time. They were, we note also, loaned equipment such as beds and mattresses with which to fulfill their role. Our point is that it cannot sensibly be said that the foster parents were conducting a, quote, recognisably independent business of their own. And the point we hope to be able to reinforce when we look at the contemporaneous records and evidence from the respondent that was before the court. Finally, we say the only children they fostered were through the offices of the respondent, which exercised the control and had the involvement already mentioned. We say in our written case, and we say today, that it doesn't matter that the local authority is not directly involved in the day-to-day caring for the child. We accept that it may be one factor to consider, but to adopt the analogy of the workplace, in modern conditions, employers will very often leave a business in the hands of capable, medium, or lower-level managers who will be expected to deal with problems arising at the coal face as part of their work routine. Moreover, the foster carers were paid by the local authority. In our case, we said that the payment is an allowance to cover costs and not a direct wage for the care that's provided. This may be slightly incomplete or inaccurate, as we'll shortly see. But whether the payment is to cover expenses or whether it's the heating and feeding costs should not be an important factor to consider, and certainly we would say that the nature of the payment should not determine whether vicarious liability exists here. And we'll look at the modern day arrangement for payments, and I will remind the court that, of course, the modern day is not that which should be applied in this case, which dates back to the 80s. Next topic, vicarious liability, activity risk and modern ways of delivery. As happens with social policy in other areas, there have been swings both towards and away from foster caring in private homes. So that you know, my intention is not to keep on going into the evidence, but rather to deal with the evidence in one chunk in about 20 minutes or so, and it will hark back to these points. But the point is this, that the defendant's child protection activity involved taking vulnerable young children from their homes and boarding them out in the private homes of foster carers.
Not all children in the care of local authorities had been taken from their homes. A higher proportion of them had been placed in what was known as voluntary care because their parents were, for one reason or another, unable to provide them with a home. That was the larger proportion of the children. We no longer call those children who are not the subject of a care order as being in care. We call compendiously all of them looked after children. Yes. But in the 80s, they were all called in care, and some of them were in voluntary care and some of them were in compulsory care.
Indeed.
So it wasn't only child protection activities. That's the point I'm trying to make.
No, perhaps it depends, I suppose, how broadly one draws the question of child protection.
Doesn't really matter.
No, not at all.
But I need to make the point that they're not all children who've been compulsorily removed from there.
Milady, I respectfully agree, and I hadn't intended in my choice of words to suggest otherwise. But yes, I can see that by using the word taking them from their homes, it might imply that that was always against the parents' will. From the child's perspective, of course, they were taken from their homes, but I accept the point and agree also that it probably doesn't matter a great deal. The purpose of taking them, the purpose of their leaving their homes was in order for them to be brought up in a better way, whether because of parental inadequacy and choice or whether because of parental neglect. Now,
would the parents be vicariously liable for the activities of foster parents in those circumstances?
No. Well, one would need to test that against the second, third and fourth factors. But I don't think it would be said that part of the business or enterprise of parents was to accommodate and maintain children.
The answer must surely be no. The parents don't have a role in placing the children in foster care. The essence of your case is that the local authority is the agency responsible for that. It is the agency which assumes the control of the children in the sense of placing them with foster parents. That is the kernel of your argument, I would have thought, that extends vicarious liability to the local authority.
The parents don't choose. The parents may choose that their children are in care. They don't choose the foster parents or placement.
And nor do they have any control over the system by which their children are looked after.
It's a long way from this sort of case, but parents, of course, sometimes ask, without the intervention of any authority, other people to look after their children, often relatives. And whether we need to address the question of whether they then become vicariously liable for anything that goes wrong, I'm not sure, but it does happen.
I agree it does happen.
Your case is, as I understand it, that whether under compulsory powers or otherwise, these children have become the responsibility, the care of these children has become the responsibility of the local authority, and that in where they are placed with other people, foster parents, those foster parents are being entrusted with the function of care, which is the local authorities. Is that right?
It is right.
So what happens if the local authority places the children not with foster parents, but in a residential unit run either by a charity or by another local authority, as often happens, or by a commercial organisation?
In the context of vicarious liability, one would need then to test that against whether, and we are still on vicarious liability only,
yes,
whether they are running an independent enterprise of their own.
I see, right. And supposing that the local authority places the children with an aunt?
It would depend. So when we look at the boarding out regulations, we can see that they have the power to do so. It would depend whether they did so as part of a relaxation of their assumption of the duty to care for the child. In other words, the child is still in care, but instead of going through our fostering system, we say, well, we are comfortable with the child being with the aunt for these purposes. And then one would have to ask the question, well, and this is why the criteria of factors as refined in COST are so important. And I could, if we want to deal with the aunt question now.
Well, do it. I'm sure it's a question you're going to come to, so take it in your own time. But it's obviously a question which has got to be addressed at some stage. And indeed, placement with the parents has to be addressed at some stage.
I would have thought that your answer must be that the incidents of obligation are not to be distinguished by the circumstance that the child is placed with a relative. If the local authority intervenes and takes charge of the child and makes a decision that the child's best interests are to be catered for by placing her or him with a relative, that doesn't diminish the responsibility that the local authority has to make sure that the placement is the correct one. So the fact that the circumstance that the child is placed with a relative, I would have thought you would wish to argue, should not make any difference. However, come back to it in due course. When you've reflected.
No. I have reflected on it plainly. I'm going to deal with it in due course. But just to, since it has arisen, our primary submission would be it should not make a difference, but that then our primary submission would be it should not make a difference.
Well, you might be able to draw a distinction. Foster parents, as it were, are recruited by the local authority as part of a means of its accomplishing its mission in a way in which parents are not, albeit the local authority may decide, may take a decision in the exercise of its care functions that the child can appropriately remain with its parents.
Oh yes, I think his parents, the child's parents may fall into a different category. I was talking about placing it with a relative other than the parents. However, it may be that you want to reflect on that and come back to it.
Of course, family placement is much, much more common now than it was in the 80s.
Yes, but
this has implications for now.
Absolutely. I mean, although you're talking quite rightly about the 1980s, there's no point in pretending that the decision in this case isn't going to have enormous impact on the current situation, is there?
There is no point.
Yeah, well,
We've got the
I think where
foster placement, we've got the modern foster placement and the placement with parents regulations, haven't we? Are they the actual current ones? We've got the 1991 ones.
Yes.
So those were the ones that were made immediately when the Children Act came into force.
Yes.
They may very well.
And we can supply the court with the current.
Well, speaking for myself, it seems to me to be sensible to look at those as well as the... Because if we are looking ahead, which presumably we are, as my Lord points out, simply to say, well, we aren't looking at them because they aren't involved in this particular case seems a rather silly thing to do, because we'll have the next case the day after tomorrow.
But
obviously we have to be careful about that.
yeah, I was about to say, because they may check.
Absolutely, but...
This is a manifestation, really, of the problem of changing times, because it's not only forms of delivery in the workplace that change, but also how things happen on the ground and how what happens on the ground is regulated.
so far as you're drawing our attention to what you say, I think, is the overriding test of integration, then obviously the circumstances of integration might change over time, though I'm not so sure how much. Anyway, we'll come back to it when you deal with family placements and parental placements.
But when we just now deal with the question of integration, I mean, one would not say that an aunt or uncle, grandfather, grandmother was integrated.
Well, wouldn't you? Whose is the responsibility for the care of the children when the child is placed with an aunt?
You've got to think very carefully about the different methods of placement. And there will be different regulations that apply to each of those methods of placement. But there is a difference between a situation in which the local authority is deciding with whom the child will live, and the parents are deciding with whom the child will live. I mean, my Lord has raised the question of private fostering, which of course is another thing, but we're looking at the responsibilities and liabilities of local authorities.
We are.
And there's a distinct difference between a child who has the status these days of being looked after, but is placed with parents, family members, foster parents, residential, and a child who doesn't have the status of being looked after, even if the local authority is playing some part in helping them look after the child. That is, and that used to be called being in care, it's now called being looked after. Your argument has to be that once the child is looked after by a local authority, the local authority is in charge of deciding who actually carries that job out, and therefore the local authority ought to be responsible for the torts which they commit in the course of carrying those activities out. That's got to be your argument.
Well,
And you'll find that each of those placements is covered by quite detailed regulations, including how they're chosen. We do need to look at them. You better get back to your script, Mr. Melton.
Taking up from the script, my lady. It was prevailing thinking is that organisations should be responsible for the risks created by their activities. And what weighed in E and the Christian Brothers cases was that the abusers were placed by the defendants in a position in which they committed a tort, the risk of which was inherent in the activities assigned to them. The risk was also present and was arguably greater in Natasha Arm's case, where foster parents can close and lock the doors to their homes, where they're expected to bring up the children as their parents would, including putting them to bed and bathing them, have the authority to discipline them, and are subject neither to the informal peer monitoring nor to the more structured controls that might be expected in a children's home outside a normal home setting. And the risk of abuse, this important next factor, is directly related, we say, to the enterprise of the authority. The commission of the wrongful act is a risk created by the respondent by assigning those activities to the foster parents. And that harks back to what Lord Reid said in paragraph 24 of Cox. So, vicarious liability, the next topic, deep pockets, the first factor. Now, the court will obviously now have deep pockets only at the back of its mind, but it is a factor not to be ignored because, as the court said in Cox, there may be situations in which it may have some bearing. This will link, we say, with the assessment of whether it would be fair, just and reasonable to impose liability if we get that far. And for the time being, what we say is that in a world where the care of children, the looking after of children, is delegated to what we may call middle-income families, who may well not be able to insure themselves against their own criminal acts, the injured people will only have an audible voice and a worthwhile remedy if they have the possibility of a remedy against an institutional defendant or a defendant with deep pockets. So, as was said in Cox, deep pockets cannot possibly be the basis for a principle of establishing liability, but it's really a concomitant of the enterprise, the person setting up an enterprise, that may be regarded as being a larger organisation than the employee. And the question is whether that has some relevance to the claimant's position here. It is important, we say, that Natasha Arms gave evidence, of course. The foster parents gave evidence too. Her evidence was accepted over theirs. And so her voice was at least heard. Next topic, control, the fifth factor. What Lord Phillips spoke of was control of the employee. This is paragraph 19 of Lord Reid, quoting Lord Phillips. But this is, as we already said, not as important as it once was. Close, day-to-day upbringing of the children was with the foster parents. We accept that there were many activities that were left and would be left naturally to the judgment of the families. What kind of food you eat, for example, what kind of activities you do with the children. And those weren't controlled by the local authority. But
well, they probably were to some extent.
They probably were to some extent. But
Because-
whether it's cornflakes or Rice Krispies or whatever, no. But certainly...
Probably would be requirements as to having a reasonably healthy diet and, of course, a religiously appropriate diet
yes.
and culturally appropriate diet.
But overall, vestigial control of the foster parent was with the local
Does
authority.
vestigial mean?
Well, we might have to ask Lord Reed, but I understood it to mean residual control, background control. In other words, not control of the day-to-day or direct control, but rather the right to call the shots. But that's how I read it. So vestigial control of the parent was with the local authority, and if orders are given by the local authority, the foster parent has to follow them. The foster parents are, for these purposes, given their own social worker employed by the authority and are monitored by the authority as a manifestation of control. And the ultimate sanction or control is that, of course, the local authority may terminate the foster placement if it should decide that the welfare of the child requires it. If there are concerns not so grave as to warrant termination, guidance can be given, or further training can be given, as we'll see. There is no need in the modern way, in order for there to be vicarious liability, for there to be involvement in or control over the micromanagement of family life. And I just mention that in the JGE and the Portsmouth Roman Catholic Diocesan Trust case, the relationship of the Catholic priest and the diocesan bishop was sufficient to trigger the doctrine, despite the considerable autonomy enjoyed by the priest in his ministry. So, remaining with the vicarious liability heading, but moving on to the next topic, this is the application of these principles to the facts of the case. And the material before you includes both the statutory material, which we may need to supplement, and expert and factual evidence that was before the judge. The statutory material defines the statutory role of the local authority and its relationships with foster parents and children in care. And paragraph 160 of the judgment of Mr. Justice Mayles and paragraph 4 of the judgment of Lord Tomlinson summarise this. But rather than, I can just flag up that they have summarised it, but perhaps I can take you to the statute bundle. This begins, for the benefit at least of Lord Kerr, at page 1561 of the memory stick. The first statute to which I take the court is the Children and Young Persons Act 1969. Page 1585.
585.
Subsection 2. If the court before which a child or young person is brought under this section is of the opinion, amongst other things, that...
Well, those are the grounds for making a care order. You don't need to go through
Okay.
them. What's the effect of a care order? That's the important thing. Where do we find that?
Go to the chart, section 24 of the... Section 24 of the Act, my lady, page 1588.
Thank you.
it shall be the duty of a local... I'm not going to read it out. The court can read subparagraphs 1 and 2 of paragraph 24.
Duty to keep him in their care while the order is in force, have the same powers and duties with respect to a person in their care as a parent or guardian would have.
Indeed.
That's basically.
Yeah, that's basically it.
So they've got the duty to keep the child in care. This is under a care order, of course. And the same powers and duties as a parent.
Indeed. And then the Child Care Act, relevant section, memory stick 1613, paragraph 18.
Section 18.
Yes, section 18 of the Act, page 1613 of the memory stick.
Section 10, I think, reenacts what we saw previously in section 24.
No, it reenacts something else.
Ah.
From the Children Act, 1948. Well, actually, it doesn't reenact it, it's new in 1980, but it's covering the same sort of ground.
This is what was obviously enforced.
This is what was in force at the time. Yes.
National Arms was taken into care. 18.1. In reaching any decision relating to a child in their care, a local authority shall give first consideration to the need to safeguard. So primacy is given here to the need to safeguard and promote the welfare of the child throughout his childhood, and shall, so far as practicable, ascertain the wishes and feelings of the child regarding the decision. And so the point is that the obligation is to give primacy to the need to safeguard and promote the welfare of the child with all that entails. And then, next page, 1614, paragraph 21, in the discharge of that duty, the local authority is given power to discharge the obligation in several ways. A local authority shall discharge their duty, and this may be important, their duty is to provide accommodation and maintenance for a child, which we say is part of the obligation that a parent would have. And here, this is an example of one of the duties that a parent would have and that the local authority has assumed, is to provide accommodation and maintenance for a child in their care, and they can do it in one of the following ways. And by boarding her out, in Natasha Arms' case, on such terms as the authority may determine, or by maintaining her in a community home, or in any such home as referred to in section 80, or by maintaining her in a voluntary home, or by making such other arrangements as seem appropriate to the authority. And then, and this is germane to the question asked by Lords Hughes and Lord Clark, 2, without prejudice to the generality of subsection 1 above, a local authority may allow a child in their care, either for a fixed period or until the local authority otherwise determine, to be under the charge and control of a parent, guardian, relative, or friend. And what we say is that in that situation, it is no longer the authority, the business that is, or rather, what we say is that the authority has not selected these people or delegated the performance of their duties to these people.
It's an alternative, you say?
Yes. And then the boarding out regulations behind tab 5, memory stick 1639. These are the regulations then in force. And number 4, regulation 4, a care authority or voluntary organisation who have arranged the boarding out of a child shall not allow him to remain boarded out with any foster parents if it appears that the boarding out is in his best interests. That's really an illustration, but in a regulation of a way in which the need to promote and safeguard the welfare of the child might be carried out, might be performed. In other words, if we're not happy with the foster parents, then we remove the child from the boarding out. 5, and then visitors can be appointed independent visitors, so the equivalent of advocates these days. Number 5, where a visitor whose duty it is under these regulations to supervise the welfare of a child considers that the conditions in which he is boarded out endanger his health, safety or morals, that visitor may remove him from the foster parents forthwith. That's a separate and independent person. Next page, 1642, Regulation 6, says there needs to be a medical examination both before and, in the case of Natasha Arms, before the placement takes place, and at least annually during the course of the placement.
So these sections apply in this case?
These sections apply in this case. And I then move on to I'll just mention that at the end of the boarding out regulations, there's an undertaking, draft form of undertaking that is required to be given by the foster parents. That's a pro forma. I'll come to the actual undertaking that was given in this case, which is just filled out in relation to Natasha Arms. For the next half an hour or so, I suspect, I'd like to take the court to 3 witnesses and a few pages of contemporaneous records. The witnesses, so this is the next topic really, it's the factual and expert evidence that was before the court. The 3 witnesses are, I'll list them now and I'll come to them separately. Felicity Schofield, who's a social care expert. Jane Austin, a senior fostering manager, and Fiona Becker, a more junior fostering manager. I use those shorthands. Page 505 of the core bundle, core volume. I start, as it were, in a hierarchical way. This is the sort of overview of an expert not involved in the this authority. And what happened was, just to explain, Felicity Schofield gave evidence that was the subject of challenge in connection with the failure to supervise and monitor the placement. But she also gave this supplemental social work report to deal with the questions of the structure of social work at that time. Now, and so we can see page 505 of the bundle. She's prepared the report at the request of Nottinghamshire County Council and its liability insurers, and she describes, paragraph 5 at the bottom, that she's been asked to provide expert evidence to describe, explain and delineate the nature of foster care and placements, specifically between 1985 and 1988, and more broadly. In particular, she's been asked to comment on those things there.
If we're going to look at this, which may well be by consent, are we to take it that this is evidence which was not in dispute?
This was not in dispute. So she gave oral evidence, but as
Yep.
far as this is concerned, she was not challenged on this.
Thank you. Thank you very much.
And she was, as I say, the respondent's witness. Paragraph 9, we have for historical reasons only, we have the genesis of the word boarding out. Boarding out regulations existed still in 1955, but it seems to have come from when children were in the workhouse and they needed somewhere to stay overnight, so they'd be boarded out by the work.
Another old-fashioned expression, boarding out.
It is. It is.
I think it dates back to the Elizabethan Poor Law.
I remember my grandmother always used to say, "You'll have me in the workhouse," and so she could still remember the workhouse. But I think that
Well, the workhouse was later than the Elizabethan
Yes.
Poor Law,
But
but the Elizabethan Poor Law provided for children to be boarded out.
I didn't know, my lady Hannah, I'm grateful for the... but it may be, therefore, that this is...
It's been going on for a very long time.
On the facing page. During the 1960s, the proportion of children in care who were boarded out began to decline from 51% in 1966 to 41% in 1976, so fewer children in foster parents, more in children's home, with institutional care being the preferred option. However, there were major shifts in policy, planning and practice in relation to the care of and treatment of children in care in the mid-1970s, and foster care became, and has remained, the preferred method of substitute care. These shifts appear to have been influenced by four major developments. The general move away from institutions towards community care and normalisation, studies highlighting the negative impact on children of residential care, the apparently successful fostering of troublesome adolescents with specially selected, contracted and fee-paid carers, and, not unimportantly, 4, the adverse financial climate of the mid-1970s and the escalating costs of residential care. The late 1970s, paragraph 12, saw the introduction of schemes for the family placement of hard-to-place youngsters. And over the next 10 years, the majority of local authorities developed such schemes, with specialist fostering officers being appointed for the first time, and a growing interest in the recruitment, selection, training and support of foster parents. So this is perhaps relevant to this question of integration. So we're recruiting a team of outsourced workers. Fostering in the 1980s to the present. The policy shift described above, which began in the mid-1970s, has continued to the present day. In 2013, according to her, there were 68,000 children in care, of whom 75% were in foster care and 12% in residential settings. The experience of family life is seen as preferable to living within an institutional setting. And as a general rule, children and young people are only placed in a home when placements in foster homes either cannot be found or have failed on occasion. Placements in children's homes can lead to a deterioration in a child's behaviour because children can be, quotes, contaminated by the challenging behaviour of other residents, thus reducing their chances of a successful return home. And then the next paragraph remains to the question of integration and control, and to an extent risk. Foster parents who have been trained and are supported by specialist fostering social workers. We'll see this, so that the child has his or her social worker and the foster parents have their social worker. they can help children to overcome. So the foster parents are helping the children to overcome, fulfilling, we say, part of the objective of promoting the welfare of these children, to overcome some of the behavioural difficulties which contributed to them coming into care. The best. So this is the aspiration for a foster parent in those days. The best of foster parents are able to work with birth parents to help them build their confidence and expertise in parenting in preparation for resuming the care of their child. This improvement in behaviour and work with birth parents is harder to achieve in an institutional setting for those two reasons. And then at the bottom of that page, paragraph 19, it seems there came an increased emphasis on long-term planning, underpinned by the 75 Act, which required first consideration to be given to promoting the long-term welfare of the child. The emphasis on social work practice moved increasingly towards trying to avoid long-term fostering situations and to use fostering as a temporary state pending a more permanent solution. And when we look at one of the dissenting judgments, I think it's of Arbor J in one of the cases, which it has some relevance that the foster placement is often of relatively short duration and can arise in emergency situations. And we'll see the foster parents as being described in this context as a resource for the local authority. And then this expert goes on to consider page 512 of the memory stick. The relationship, and she gives it this subheading, the relationship between the child, the local authority, and the foster parent. And not to labour the point, we say this is all to do with this question of integration. It can be seen, therefore, that the precise distribution of... I'm so sorry, I need to start higher up that page. 35. The first government guidance on the subject, still on page 512, the first government guidance on the subject, the Guide to Fostering Practice, 1976, stated, fostering is not in itself a single identifiable method of care. It offers a range of placements which have in common only the fact that they provide care in a family setting. Unsurprisingly, therefore, she says, much of the social work writing about fostering in the 70s and 80s, early 80s, stressed the foster parents' difficulties in understanding their role.
Well, the difficulty was a very simple one. They had to promise to bring the child up, look after the child and bring the child up as if she was their own, but also to promise to give the child up at a moment's notice. Now, that's a very, very difficult thing to do.
Extremely difficult. Those of us who know this from cases and from people that we know.
But what is the relevance of this to the issue that we have to determine?
Well, it foreshadows the what I will describe as the as the fluidity and intermeshing of the roles of the foster parents, of their social worker, and also of the child's social worker. But perhaps Lord Kerr is correct in the sense that perhaps that paragraph isn't...
Well, it seems to me that it might be relevant to consider the circumstance that before the movement away from a preponderance of caring for children in institutions, you might want to argue that if abuse had taken place within those institutions, there can be little doubt that, judged certainly by contemporary standards, the local authority would be held to be vicariously liable, whatever the circumstances in which that abuse took place, and that it might be considered, I merely put this forward as a suggestion, to be somewhat anomalous, that situation should be dramatically or radically changed by the circumstance that children were mainly fostered away from institutions.
We do argue that, we put that in our case, my lord, and when I come to deal with whether we have to deal with what is fair, just and reasonable, whether it's fair, just and reasonable, I intended to deal with it under that heading.
Yes.
Trying to stick for the time being with this question of the second, third and fourth factors. But it is crucial, we say, that the remedy of a child should not depend on the politics of the time and the philosophy of the time as to whether once a local authority assumes the control over the child's welfare, it does not matter whether it's delivered by the mechanism of a children's home or by a foster placement. But, as I say, so as not to keep on jumping around, what I wanted to do is to introduce the court to this evidence and to try to develop this question of integration, or to see how this witness, at least, what her evidence contributed in terms of that question of integration. Paragraph 38, it can be seen, therefore, that the precise distribution of responsibilities between the local authority, the social worker, the foster parent and the birth family has never been prescriptive, and intentionally so. This is in recognition of the very different circumstances covered within the regulatory framework. Arrangements for specific placements will reflect the legal status of the child, the purpose of the placement, the skills and experience of the foster parent, and the circumstance of the child and their birth family. Then, on the facing page, paragraph 41, generally, foster parents looking after children on a short to medium-term basis, such as was the case here, would have less involvement in decision-making, albeit some, I say, although this might depend on an individual social worker and on the role being played by the birth family. 42. However, the major decisions about children in care have always been the responsibility of the SSD through the work of the social worker, ideally in consultation with both the birth parent and the foster parent, depending on the individual circumstances. Therefore, it's the SSD which decides on the level of contact with the birth family, and then those other matters, which we've summarised already. And then 43, areas where either the foster parent or the social worker could become involved, so either one or the other, might be attending a parents' evening, making day-to-day arrangements for contact with family members, dealing with behaviour or attendance issues at school, buying new clothes or equipment. If the foster parent needed childcare because they were working, generally the social worker would make the arrangements because of the need to ensure that a substitute carer any substitute carer is suitable. Sometimes extended members of the foster family are approved to care for the child in the foster carer's absence. And then, this is really only part and parcel of what Lady Hale has said. Next paragraph, middle sentence. Foster parents would be expected to help improve difficult behaviour and help a child cope with earlier abuse or trauma. So they are, by assuming the foster parental role, fulfilling part of the greater objective of the business of the local authority, which is to promote the well-being of the child. The next witness is at page 433. This is Jane Austin, the senior fostering manager who I've already referred to. And paragraph 8, she says, there was a review and scrutiny of social work practice following the death of Peter Connolly, who was in care, brackets, looked after in modern parlance. Bottom of 435. Following the death of Peter Connolly and the subsequent national scrutiny of social work practice, the Council has seen an unprecedented rise in the number of children in its care, from 488 in 2008 to 906 in 2013. Now, the Council was unable to meet the demand for foster placements from its internal provision, and as a result, it had to purchase fostering services from the independent sector.
Can I just pause there? What is meant by its internal provision?
Presumably means the, tell me if I'm wrong, or at least possibly the respondents will tell me if I'm wrong, it will mean the foster parents which the local authority had itself recruited. Local authorities go in for foster recruitment campaigns quite regularly, but if they don't have enough through their own efforts, they may have to outsource to independent contractors.
Independent contractors. Yeah. So the independent fostering sector, she says, is required to work to the same regulatory framework as required of local authority provision of foster care services. All foster carers, whether approved by a local authority or by an independent fostering provider, are subject to the same regulatory requirements and national minimum standards. The most significant difference between internally and independently provided foster care is in the cost to the council. In Nottinghamshire, the weekly cost, this is current, weekly cost for one child in an internally provided foster placement is £402, whereas the weekly cost for one child independently provided is £800.
Now, what's happening there, presumably, where independently provided foster parents, the placement is with independently provided foster parents, it's done through an agency of some kind, is it?
That is.
Which is a commercial operation, is it?
Indeed.
And is a business of its own, I suppose.
It's a business of its own.
Right.
So the actual foster parent would be an employee, would he or she, by the of the independent contractor?
I don't know whether they have employment status, but I would venture
It won't be universal, whatever it is. My lord and I, who spent quite a lot of our time dealing with these cases, will have encountered some professional foster parents who are actually employees, whether of an agency or of a local authority. Other foster parents, again, whether with an agency or with a local authority, will not have the formal status of employees. Some do, some don't. It's comparatively rare for them so to do, but there are some that are professionally recruited and paid.
And so they may have that formal employment status.
They may or they may not.
Or
More likely that they won't.
Or they may simply be on the books, as it were.
They may be on the
That's right.
Yeah.
The relationship may be akin to employment.
But would you say that the agency is then... Yes, of course, you're going to say they're all akin to employees. You're going to say that. Yeah. But would you say that the agency is then vicariously liable for the misdeeds of the agency's foster parents? Or would you say that the local authority remains vicariously liable? Or would you say that they both are in a via system sort of way?
Point one, they are alternatively...
Not at all.
This
Well, we know what the respondents would say.
This actually is interesting because the position is different with regard to the non-delegable duty point. And this is one of the reasons why it may be important to deal with non-delegable duty. Because, of course, one cannot divest oneself of that duty by delegating it to an independent contractor. What I will say on behalf of...
It avoids all these tricky legal questions.
Well, there is a way of...
It's not necessarily tricky,
No,
but
it's
you
not.
may have to give inconsistent replies because they are different doctrines.
Yes, quite.
I hope I'm not going to give an insight. What I will say on behalf of Natasha Arms, seated behind me now, is that, well, first of all, I don't need on her behalf to answer that question as to whether, if she had been independently fostered, the council would be vicariously liable. But I could see a formidable argument, if it were Mr. Ford or Mr. Weitzman on the other side, to say, actually, no, that independent fostering agency has its own independent business that it runs, and indeed it even employs some people to do just that. So it may be that in relation to that, I might struggle slightly, and I might prefer, in that respect, my argument under non-delegable duty, which embraces the position of the independent contractor.
Well, yes, but where are you, Mr. Milton?
Yes.
Would the agency itself be vicariously liable?
Well, that would depend on the relationship between the agency and the employee, in inverted commas.
Yeah, the parent,
yeah,
the foster parent.
But to throw it out there, I would say it is very likely that their relationship would satisfy the test adumbrated in Cox. But without knowing the facts of such a hypothetical case, I couldn't answer. But as I say, I think I might struggle before you to persuade you that they were not running an independent business. And so I might have to resort to non-delegable duty.
But it's being an independent business doesn't answer the question, if you look at that in isolation. I mean, in Christian Brothers' case and Via Systems were to do with people who were employees of independent businesses.
Yeah.
But it was nonetheless vicarious liability by the non-employer because their activities were so integrated into the way in which it carried out its own business.
And I suspect, as has been said by Lady Hale, that actually there is no uniformity in practice and that some independent fostering agencies are integrated and some may not be. I think I stopped talking because we were wondering what internal meant. And so I think I stopped at about 6 lines down and page 436. The independent fostering sector is required to work for I've read that. All foster
Yes,
care...
you got to the end of paragraph 8.
I'm sorry, thank you. So then, and the facing...
And this is all the position now, is it?
This is the position now.
Yeah,
Yeah.
basically.
And I infer that it was not the position, it doesn't matter, for Natasha Arms' case, it doesn't matter. I infer it wasn't the position in 1970s because this change only took place following the death of Peter Connolly, which was much later.
Well, I think...
Well, according to this expert.
No. She's talking about the situation in Nottinghamshire.
Right.
Again, my lord and I will have encountered independent fostering agencies before the rapid increase in the numbers of children in care as a result of the response to the Baby P case and other cases. So the practice of using outside agencies was established long before that. It just may be that Nottinghamshire, fortunately,
That prompted them.
having such an excellent social services department, was able to recruit as many foster parents as it needed until the really dramatic rise. But there were other local authorities that were regularly using agencies. A lot of the London authorities were.
Well, I can only speak myself about the late 1990s, early 2000s, but they certainly were then.
We'll see the detail of this when we look at the documents in this case, but if we go to the bottom of page 438, the last 5 lines, describing the position, and this does seem from the documents to have been the position in the 1970s and 80s. The officers within the council, so that is to say the social worker for the child and the social worker for the foster parents. The officers within the council are located in two different service areas, so-called. One service area provides a social work service to the child, and the other service area provides the social work service for the child through the foster carer. A foster carer's social worker is called a supervising social worker. And I think I'm right in saying that Fiona Becker was the supervising social worker. And the point of this is, again, on integration, and it's almost like a line management role. So when we read on 15, the child social worker is responsible for executing the tasks identified within a child's care planning and review process. The foster carer's supervising social worker is responsible for monitoring the standard of care being provided by the foster carer and for supervising the foster carer's conduct and performance. The child social worker and the supervising social worker work closely together to ensure that the child is receiving good quality and safe foster care. However, within that working partnership, each worker has an individual and distinct role. And so we say this is a framework or a structure into which are integrated and closely integrated the foster parents. 16, a supervising social worker is responsible for assessing, supervising and supporting a foster carer. A fostering team manager is responsible for ensuring that a foster carer's performance and conduct is reviewed annually. Now, she exhibits, I'm not going to take the call to it now, she exhibits Nottinghamshire's strategy for 2012 to 2015, and at page 499 of the bundle for your reference, but I'm not going to take you there, she lists the, I think we ought to look at it briefly, but this needs to be with the strong caveat that this is the contemporary position. Page 498, fees to foster carers. The fee awarded to a foster carer is based on the foster carer's terms of approval, skill, experience and qualifications. Payment for skills levels. Payment for skills provides a career pathway for foster carers and recognises and rewards the skills, experience and training of a foster carer in the payment of a weekly fee. Most foster carers, unless approved under former fostering schemes, emergency foster care, fostering futures, contract care and home from home provision, are paid under the payment for skills provision. The fee is generally referred to as the levels fee, foster care, and then you get a fee depending on how good you are. Now, this is just one snapshot. It's a snapshot that is decades after the matters with which we're concerned. And it's Nottinghamshire. But what we say it does is exemplify the less formal assessment, appraisal, and reward for skills that was going on, as we'll see when we look at the individual documents in the Tasha Arms case. Then Fiona Becker, she was the supervising social worker for the foster families. And her statements are at 375 and 427.
Sorry, 375 and 1?
427. And at 376, she describes her role. Well, paragraph 4, on that page, she worked for Nottinghamshire between 82 and 90, first as a social worker, then as a substitute family worker, the foster parents being, of course, the substitute family. And she describes her role. The work of a substitute family worker is primarily with foster and adoptive parents. I was not a child social worker. The role of a substitute family worker was to recruit and assess individuals as foster and adoptive parents, prepare them for placements and support them in their role as carers, sometimes for children with very challenging behaviour. I would also review their training needs and coordinate or provide training.
Does she make it clear anywhere whether when she says she speaks of adoptive parents, she means prospective adoptive parents or those who have adopted? Don't worry if you don't know, we'll find it later.
Perhaps Mr. Davey or someone on the other side.
It may well be prospective, I don't know.
One would assume that if she's assessing people
Yes.
as foster parents or as adoptive parents,
Yeah.
she is asking herself, will they be suitable?
Yeah.
In which case they're prospective adopters.
So one would think.
Some foster carers, she says, were particularly skilled in working with a particular age group. So, for example, if I was looking to place a teenager, I would first consider whether any carers with this expertise could take this child. I monitored placements insofar as they related to foster carers. Examples of issues I would cover are to see how they, the foster parents, were coping with the child. So this is an appraisal or assessing how the employee, I'll use the word, is coping with the job. To see how they were coping with the child or children in the placement, the impact the foster child was having on their own children, what difficulties they may be experiencing, what support or information they might require, and how a change in circumstance might impact on a placement, i.e. if one parent was made redundant, and liaising with the child's social worker where necessary.
So now these social workers, they were employees of the...
They're employees.
And so if they were in breach of their duty, there'd be no doubt that the local authority would be vicariously liable.
That's correct.
For that. And was that part of the allegation which failed?
It was.
I mean, were they allegations against these particular social workers?
What's the allegation?
I don't necessarily mean these particular people, but the social workers of the day.
The social workers responsible for Natasha Arms were an allegation was made that they had failed under the Boland test in their professional responsibilities.
Yeah.
Yes, there was a claim initially that the appointment of the foster carers was itself a negligent act, so that would have been an allegation against this particular social worker, but that claim was struck out in early stages.
But if those allegations had succeeded, there was presumably no issue that the authority would be vicariously liable for their breaches of duty.
Indeed.
Is that right?
Yes.
But, okay, thank
Whether the fostering social worker or the child social worker, and both allegations were
Thank you.
made.
Yes, they would be classically employees acting in the course of their employment.
Can I ask, going back to the document you took us to a little while ago about financial information, I just wondered if you happen to know, there's a tax relief scheme. It just occurred to me to ask whether they're taxed under, whether the foster parents are taxed under Schedule D or Schedule E. If you happen to know.
Forgive me, my solicitor may know.
Good question.
Almost good point. Mostly independent contractors. They'll mostly be independent contractors for that purpose.
Can I come back with that answer at 2:00?
In practice, it may be that very few of them pay any tax on this, but if there were taxed, it might be helpful to know.
Just make a note.
Well, we're assuming, we've been working on the assumption that the foster parents with whom we're concerned were not employees of the local authority. That is the underlying premise of these proceedings, because if they had been, we wouldn't be here.
No, and I will make the concession that they were not formal employees, properly so called, of the authority. Then if you, I'm going to take you to page 380, which is still within the statement of Becker. It's this. It depends what one means by integration, and it may be that I'm partly missing the point, but just forgive me if I am. With paragraph 22, this describes a board, a whiteboard, or a board in the team office which listed the foster carers, which children are placed with whom, and what vacancies there were and with whom. And she says, if I had dealt with the placement on a duty basis, and I can't say after all this time that I did deal with Natasha Arms, then I would have worked out who had room, who was approved to take what age of child, and what the likely impact would be if another child were there. A lack of resources was always an issue, and sometimes we didn't have the luxury of choice, but we would always look for the best fit where possible. So one has the idea of the child social worker saying, we need someone urgently or not so urgently for Natasha Arms, and then the substitute family care team office saying, right, well, what resource do we have? And this is likely to come free in such and such a time, or this is not ideal because the child is only 9, but nevertheless, we've just got to make do with what we've got. And so that is, we say, evidence of integration. And
so just going back to the point we were on a moment ago, paragraph 23.
Yes.
That's part of the allegations which were struck out, is it?
Well, failed.
Yeah, it was, in fact, there was a summary judgment application.
I beg your pardon.
No.
Yeah.
In connection with that, there was a summary judgment application because the claimant could not put forward any supportive expert evidence to suggest that by judging by the standards of the day, that was a breach of the professional duty. And so the defendants applied to strike that claim out, and that was successfully the subject of a successful strikeout.
It was summary judgment, you're right.
Summary judgment.
I understand.
It was a defendant's application for summary judgment.
It was the defendant's application for summary judgment on the basis that the allegations of professional negligence, as they had to be framed, were not supported as they had to be by supportive expert evidence.
Which decision the judge arrived at after hearing the expert evidence in question?
No.
No?
It was at a pre-trial hearing.
Beg your pardon. Thank you.
So that's what happened.
Okay, thank you.
And then she exhibits a number of documents to her witness statement. And page 397, towards the bottom, this is an agreement for fostering placement by by 2 of the foster parents concerned here, but not in relation to Natasha Arms. And towards the bottom, you can see that they've got specific tasks. So specific tasks for foster parents. 1, sorting out glasses. If rehabilitation plan progresses, then the mother to help the birth mother, learn routine with the boys, and also assessing the relationship between mum and children's access visits. So this isn't unexpected, but so when one was asking, are they doing a business of their own, or are they acting on behalf of the authority, or are they integrated? Here they are. I assume it must be an extremely valuable resource, is that you can actually see how the child behaves day to day, and more importantly, how the child interacts with the parent, if they can make that judgment.
Well, integration isn't a term to be isolated from its context. It's integration into the organisation of the local authority. What are the essential features of integration into the organisation, which must be present?
Well, the integration needs to be seen in the context of the duty of the local authority. And so we do not say, for example, that they were integrated in the building, having a desk, or having a badge or uniform, or even a formal appraisal structure in the way that an employee would be. But what we say they had to be is integrated into the fulfillment of the council's child protection role, and in particular integrated into the function which the council delegated of accommodating and maintaining the child.
Well,
Just going,
the respondent may say that really doesn't capture the essence of integration at all. Of course, the foster parent plays a role in the fulfillment of child protection role, and it plays a role in the function of accommodating and maintaining the child. But that doesn't address the question of integration. I mean, simply because you're discharging that function doesn't necessarily mean that you're integrated into the overall function of the local authority. And I suspect that the respondent may argue that it must partake of something of some further dimension than simply playing a role within the overall care for the child. I mean, is there something about the use of the expression integration which connotes a special dimension or element?
in answer to the second question, no. And if I may respectfully disagree with the first proposition or question, we say that there can be nothing more integral to the promotion and welfare of the child, and nothing more integral to the local authority's duty to maintain and accommodate the child than bringing her up and feeding her as if in a family setting. We say that is absolutely integral for these purposes. And perhaps I should just go back to the Act, because one of the points taken, and this came up in Woodland, is whether the obligation of the authority is to arrange for the provision of accommodation or to provide the accommodation. And if we look at page 1614 of the bundle, section 21 of the 1980 Act.
Sorry, just give me the page again, will you?
Yes, 1614 memory stick. It's in the statutes bundle. So it's behind, my Lord, it's behind tab 3 of the statutes bundle and memory stick 1614. So, a local authority shall discharge their duty to provide accommodation and maintenance for a child in their care in such one of the following ways as they think fit, by boarding him out. And So the duty to provide accommodation and maintenance is subsumed in the duty to promote the welfare of the child. They have a duty to accommodate and maintain. And as I'll say this afternoon, we say that's a duty that sticks with them. But on this topic of integration, if the question is, are the parents integrated in the performance by the council of its child protection role and its duty to accommodate and maintain, then the answer must be yes, we say. Otherwise, one's looking really more at the integration within the setup rather than within the scheme. But even if it's the setup, then what we say is that these contacts between the social workers and the foster parents and between the supervisor, the substitute family social worker, requiring these things to be done. And most importantly, we say appraising and guiding and educating and training and monitoring. We say that although the question has to be asked, are they integrated? We say there's only one answer to that question. But from recollection, what Lord Justice Ward said, and I don't ask you to go there, and what Lord Justice Ricks said was that this needs to be seen in context for all relevant purposes. They need to be integrated or integrated and carrying out the business. And so one has to ask oneself then, well, what are the relevant purposes? And from this side of the room, what we say is the relevant purposes are the protection of the child from harm, which objective is fulfilled by the provision of accommodation and maintenance. And page 408 now of the memory stick. So we're now back into the core volume behind tab 7, page 408. And this is a document attached to the statement of Becker, of course, because that's where we are. This is the second page of the... Right, just read it, if please. The bottom of page 407, dealing with how recently Natasha had been with this family. But then the next page, training. I have encouraged the foster mother, to attend training sessions, / foster parent group meetings, but she says this is difficult because of the distance. She and her parents are now attending the target group run by another area, which she says she enjoys. Now this monitoring of the need for training and the provision of training and the assessment of foster parents to be receptive towards training is, we say, all part of what we at least say is the integration test. And then on the facing page, 411, no, it's not the facing page, sorry, it's 2 pages later. This is the same foster parents, but a different, same foster parents and Natasha Arms. Page 411, working with social workers in the department. In general, the parents find there is insufficient contact from social workers and information. They have therefore not always been able to prepare children for events in the way they would wish to. Fiona, that's Fiona Becker, is able to act as a mediator between them and the children's social workers to attempt to improve the situation, and then more about training needs. And on the next page, still with training, which we do see as important, purely by coincidence, this is Fiona Becker writing, I did a training session on sexual abuse with the foster parents and another set of foster parents on 1st March 1980. In this, I introduced them some basic factual information on sexual abuse, signs and symptoms that may be indicative how to talk to children about the abuse. I showed them the Kids Say No video and left them articles to read from the Bath Pack and the NFCA leaflet. They seem comfortable in talking about sexual matters and are very interested to learn more about this whole area. And then page 418. This page I draw your attention to because I say this is very much like the management of an employee, be it not the test. So, transfer summary 418, another memo by Fiona Becker. I think the parents take a while to get to know well and do not readily talk about difficulties they may be experiencing, either with children or their social workers. So it is necessary to encourage their worries, etc. They are both open and receptive to training, but feel it's too far to travel to Nottingham to join training events. Hence, I did a training session with them elsewhere. Clearly, they will need more input on sexual abuse. And I know from their review that they would like more input on direct work with children. I also doubt that they had much input on parenting in a multicultural society when they were assessed in 1982. They are close to the foster mother's parents who also foster, and together they have started to attend the... As I say, from the perspective of this side of the room, these are very strong examples of the kind of integration that should be the badge of the modern doctrine of vicarious liability. Lest you were worrying that I'm going to go beyond the time I've allowed myself to deal with this, I'm not, and we are on time.
You wouldn't be allowed to go beyond the time we've allowed you to deal.
No, what I mean is...
you could make what use you want of the time available to you.
You obviously weren't worrying. Page 427 is the second witness statement made by her. Paragraph 4. The role of the foster carer, the substitute family care worker and a child's allocated social worker were distinct, although at the same time we were working in partnership to promote the best interests of a child. That includes the foster carer within this partnership. Foster carer role. In assessing, paragraph 5, in assessing and approving individuals as foster carers, the local authority was entrusting them to provide appropriate substitute family care for a child. This was their role, to provide an alternative family life. And then she says she didn't interfere with the day-to-day activities. A foster carer is expected to provide good physical and emotional care to a child, liaise with the child's social worker, follow the plan for the child. So this is the objective of the business, of the enterprise, to which the employee here must follow. And then she describes her role in supporting foster carers, which is very much that of, we would say, the line manager in modern life. I'm going to read it. A substitute family care, second sentence in 7, was a constant in the life of a foster carer. And this was generally a longer-term relationship than the relationship between a social worker and a foster carer. This was because children could be placed for very short periods of time and so could be ever-changing. I would contribute to decisions being made about children who were placed with specific foster carers. In formulating the best plan to meet a child's needs, a social worker's focus would be on the child and the foster care was simply seen as a resource. I would be taking into account a foster carer's particular strengths and weighing up what the foster carers could offer in terms of providing the right kind of family life and the parenting needs of a child. And then paragraph 12, I would tailor the frequency of my visits to the needs of the foster carers. For example, I might visit more often if they needed additional support in managing difficult behaviour, or I would go less frequently if they did not. This is paragraph 12 at the bottom of 429. I'm sorry, Lord Kerr. I was also available by telephone as and when they needed, but there was no set time each week. And then the remaining paragraphs deal with reviews and the fact that it was possible for foster carers to be deregistered. And as we'll see, that is what ultimately happened with that pair of foster carers. They were deregistered. And then page 431, last paragraph, and I'm going to move away from Becker now. Social workers viewed foster carers as a resource to meet the placement resource of a particular child. This could be short-term or long-term.
I know that said, you showed us earlier the document which spoke of a career path where where earnings increase as expertise increases in response to training and experience. There's a different perspective on it from this, I think.
It's different in this sense, my Lord, that we can see in the modern way a more direct correlation between the levels fees that are paid, which are paid in accordance with skills and training. But we would say that the fact that they may impact on remuneration is not a material factor to distinguish the arrangement for these purposes, for today's purpose, to distinguish the modern position with the position in the 70s and 80s, because still what was happening was that the family was being monitored and to see how difficult a child they could take on, and if they could take on a difficult child, then they were allocated that. And as we'll see when we look through the file in part 2 of the index, the foster mother in question was very keen to have young children there, and they, as one can imagine, as one can imagine in the case of many foster carers, they enjoyed being part of this process and enjoyed it deeply. And so their reward, as it was seen, was, well, you can have a younger child, but you have to take the rough with the smooth and take the more difficult children too. And so we say that is a meaningful factor when deciding the question of integration. Because I think, and also the behalf of question which we say really is very clear, and the risk question which we say is very clear, very clear. So going to the smallest bundle, memory stick page 531. Relevant to the integration or control question. This is the best copy we have, I'm sorry. This is this is the pro forma undertaking completed in relation to Natasha Arms. 3, we will look after, we will care for Natasha and bring her up as we would a child of our own. She will be brought up and will be encouraged to practice her religion. We will look after her health and consult a doctor whenever she is ill, and will allow her to be medically examined at such times and places the council may require. We will inform the council immediately of any serious occurrence affecting the child. And then, and this is something that normal parents do not do, we will at all times permit any person so authorised by the Secretary of State or by the council to see her and visit our home. So they're opening their home for inspection. And what's more, they're allowing this child, in other respects, to be treated as a child of the family, number 6. We will allow her to be removed from our home when so requested by a person authorised by the council. Now, because I don't want to run out, or rather use up my allocated time, I'm just going to flag up further pages that the court may wish to read that are germane to this issue. Although page 537 is the next. As you will have read, one of the homes in which Natasha was abused was a family group foster home. And in the summary of the facts of the case, you can see that there were, I think, 9 children plus the natural children there. And this letter relates to that placement. And why I draw the court's attention to this letter dated 23rd October 1979 is that the local authority had, for these purposes, a system of designation. And these parents' home was designated as a family group foster home. So the designation is described in the first sentence, and then...
Please, could you just remind me of the page number?
Yes, 537, my lady, sorry. The bullet point is this. This was a large home. In order to be able to accommodate large numbers of children, the authority designated some homes as a family group foster home. This placement where Natasha Arms had that designation, and certain other, and we can see that specific arrangements for their situation were set out in a document but were summarised there. So an expectation of, a mutual expectation of training and support by a social worker. It's agreed that, moving on, page 540 is an example of where equipment is lent out to a family.
Five, 540.
540.
Yep.
Apparently they haven't been getting some equipment back from families. So
Yeah.
it's just, and then page 542 is evidence, further evidence, we would say, of appraisal and management. .545 is their annual review. Report for annual review on the family group foster home, and this is the family group foster home where Natasha Arms was abused. And if we look at page 545, we can see the long list of children in the home and the evaluation by the fostering officer, Mr. Wood, of the foster parents. And he describes their considerable strengths and describes their weaknesses in the penultimate paragraph. Interestingly, I should just say, in the light of what Lady Hale was saying an hour or so ago, one of their strengths, number 4, was ability to, open quotes, let go when the foster child moves on. Their weaknesses as such are not personal, but instead due to running a family group foster home, i.e. not ideal for most very young children on a long-term basis if an alternative suitable smaller family home is available. The majority of young children settle more easily into a smaller family. However, having said that, the Allisons, due to their commitment and endurance, offer an exceptionally high degree of security to any child placed with them. So we have this comment about them running a home. And the point was made by Lord Justice Tomlinson, I think it was, that we didn't draw a distinction between the family group foster home and the smaller placement, and we don't. We say that this is an extension of the normal situation. What you are doing is running a home for an authority whose legal obligation is to maintain and accommodate the child. And then the conclusion of Mr. Wood on the next page, 546, memory stick, is he recommends that they continue as previously and they can continue to be used as emergency foster parents.
So over what period was Miss Arms, Natasha, there?
I think it was 4 months. It's in the
It's a little after this, isn't it? This is about 3 years before.
Yeah, thank you.
Yep.
I'm obliged. And then page 560, memory stick. Discussion, this is another review, 1986. Discussion, this is amongst the staff at the council. We all agree that the best use that can be made of what the foster parents are offering for next year is for them primarily to be used as a short-term resource, in addition to the children placed with them on a long-term basis. Their skills in working with often distressed or very needy children, etc. And then page 568, a review, 26 January 1989. In answer to Lord Hughes' question, with that family, Miss Arms was there between 1985 and March 1985 to March 1986.
Yeah. Thank you.
Page 568, discussion. The father informed the meeting, this is under the heading discussion, and the topic is management. The father informed the meeting that the family had had their annual review in November, which he and an officer had been present. They had recognised and acknowledged that there was a high concentration of children in the family who had been sexually abused, along with children who were moving on to adoptive placements. It was acknowledged then that the family was overloaded, in the main due to the 3 younger children from a different family being placed with them in October 1987. There were concerns at the review about the father's attitude towards sexual abuse and the way he responded to the children. At this review, the workers picked up strong feelings of exhaustion and irritation, especially from the mother. The workers picked up an overall sense of distrust about the department, especially from the mother, who expressed a lot of feeling about a lot of her social workers. And then finally, it concludes with a letter at 577, which is when those foster parents in 1992 and the authority parted company. So what I tried to do was to start off by describing the principles enunciated in Cox to apply those to the facts of this case. As was said in Cox, and this is the next topic, in a borderline case, one has to consider two things. First, the authorities, and second, whether it is fair, just and reasonable to impose vicarious liability. As I said before, I intend to deal with the fair, just and reasonable point at the end, but I'd like to spend 10 minutes now just dealing with the authorities. Paragraph 28 of Cox says that one needs to make a judgment based at least in part on previous decisions. We say that this isn't a borderline case. But the courts below refer to two authorities where the point was expressly considered. Firstly, there's the decision of Lord Justice Oliver in S and Walsall, which was to the effect, and I'm not going to take the court to this case, which was to the effect that the whole scheme of the boarding out regulations was that the foster parents were to bring up the child as if that child was a member of the foster parents' family. Lord Justice Oliver expressed himself in terms of agency, which is probably a route that would these days be deprecated, and said that this had the effect that the parents, so this, i.e. the obligation to bring them up as if they were a child of their own, had the effect that the foster parents could not be regarded as agents of a local authority. Our response is this, that first, the scheme or purpose of the regulations does not automatically negate the necessary relationship for the imposition of vicarious liability as it now is. There's nothing in the 1955 regulations that, nor in the Act, so we have the Act that says, the Act says three things, doesn't it? The Act says you can take into care, the Act says you have parental responsibility, it says you have a duty to accommodate and maintain, and the boarding out regulations allow you to perform that function in various ways. But we say there's nothing in the 1955 regulations to upset the modern way of looking at vicarious liability. Most importantly, we say that vicarious liability has moved on since 1985. And finally, the third response to the case of Walsall is that this may well now be drawn as a fair, just and reasonable point, and this is something I'll deal with this afternoon. More important, perhaps, is the fact that the necessary relationship was found not to exist, albeit that they didn't, of course, have the benefit of the recent authorities in this court dealing with vicarious liabilities. In the Supreme Court of Canada case, KLB and British Columbia, we've dealt with this in paragraphs 25 to 30 of our written case. I just mention that so that you know where it is. I'll emphasise only the main points that we make, and in due course I'll take you to the relevant extracts. In summary, the case is very similar to this case. The Supreme Court in Canada found, in fact, that there was a personal breach of duty by British Columbia in failing to supervise properly. So the claimant won. But there was no vicarious liability. But I'm sorry, the claimant didn't win because her claim was statute barred. Yeah. And so she won on the personal breach of duty, but failed on vicarious liability and statute barred. Justice Arbour dissented on the vicarious liability issue, and we say that his dissent was a powerful one.
His?
I'm so sorry.
It's a good idea to find out the gender of the judge you're talking about. I assume this is Louise Arbour. May or may not.
By mistake, I'm
May
saying
or may
it
not
is-
have been. I mean, I could be wrong.
No, I'm absolutely, well, I shouldn't imagine there were two justices in the Supreme Court in Canada with the surname Arbour, so you must be right, and I apologise to this court and more than to her for that presumption. Assumption. Can I just, so the case is in the authorities, in the second authorities bundle, so Commonwealth authorities bundle, behind tab 20. And I'm going to wait until my reply before dealing with how the majority dealt with the question of vicarious liability. But in her judgment, Justice Arbour provides powerful reasons, we say, as to why there should be vicarious liability. It's at page 1335 of the memory stick behind tab 20. I want to finish this before 1 o'clock, and so I'm going to ask the court to highlight paragraphs 65 and 66.
They're already substantially highlighted.
And going to page 1339, highlight 76 highlights also, the point is this, that in this part of her judgment, Justice Arbour is talking about control, and she rightly says that it's the right of control rather than its exercise which is relevant to the vicarious liability analysis. And we know now that we've moved on so far as control is concerned. She then, in paragraph 77 onwards, describes the regime, the statutory regime, and the position on the ground in much the way that I've tried to do today. And we get on to what I might call the meat of it in paragraph 79, second part of that paragraph. I do not agree with Chief Justice McLachlan's statement that the government does not supervise or interfere, except to ensure that the child and foster parents meet regularly with their social workers to remove the child if his or her needs are not met. The government does indeed supervise via the social workers and may interfere to a significant degree precisely to ensure that the child's needs are being met. And then a secondary factor, paragraph 80, indicating they act on behalf of the government, in addition to the government's ongoing right of involvement, is the perception that children have of who in fact is ultimately responsible for their well-being. It's relevant to note here that foster care is by nature a temporary arrangement. And this is, or maybe, some of the importance of the fact that the families were seen as being a resource available to the council at short notice and for short periods, so that no child could have perceived that without being funny about it, that the next lot that they were going to was in charge of them. Rather, they would say, well, it's the social worker and the foster and the social services departments who are in charge of us, and now we're going to move to another family for 3 or 4 months. And then she deals in paragraph 84, 1343 of the memory stick, with whether imposing liability would interfere with their ability to maintain their position as authority figures, and she says not. 84, first line, 1343 of the memory stick. And lastly, I've highlighted page 1345, paragraph 89. To conclude on this point, the evidence reveals that as the government becomes aware of risks to children in foster care, it can respond and has responded by imposing rules and restrictions on how foster parents exercise their authority. These measures often involve continuing control over foster parents' activities, and yet they need not undermine foster parents' relationships with foster children or deny foster children the experience of a real family. Rather, they reflect the reality that children in foster care remain the responsibility of the government, which is their legal guardian. Thus, it is my view that foster parents do in fact act on behalf of the government when they care for foster children, and it is therefore fair to impose vicarious liability in this case.
Her approach is again an agency approach. She makes it clear in paragraph 71, two-thirds of the way through it, that she thinks the relevant question is whether the foster parents act on behalf of the government. And that's then the test that she addresses in the paragraphs that you've taken us to. I'm not sure that the Cox approach was quite as focused on agency as that.
I respectfully agree. It was 13 years before Cox,
yes,
obviously.
And in a different jurisdiction.
Sorry, that goes without saying. But the principal reasons why Justice McLachlan and the rest of the court decided there shouldn't be vicarious liability were, one, control. You need to be actually controlling the day-to-day to be liable. Second, we can't do it because it will undermine the authority of the foster parents. And third, they can't be said to be acting on behalf of the state because they're acting on their own behalves in bringing up the child as a member of their family. And so the response, as it were, in the dissent of Arbor J deals with the focus of McLachlan J, which had been on the question of control and behalf. But I entirely agree that this is more focused from the perspective of agency than from the perspective of enterprise.
Is that a convenient moment, Mr.
I finished, yes.
We'll look forward to hearing from you again at 2:00.